Thank you, Ludmila. Good morning, everyone, dear colleagues. I am very thankful for your invitation, and it's a great honor for me to talk at the event of this caliber, especially with the presence of our Belarusian colleagues, leading experts on international law. I am very excited to have this online format and see Professor David, uh, Professor Ambos, Professor Žilinskas, Professor Žalimas. I would like to apologize in advance because I will not be able to attend this event fully. There's a plenary session of the European Committee Against Torture, and I have to attend all the hearings. As everything happens online, it is great because I can move just in a matter of a couple of minutes from Kyiv to Vilnius and then from Vilnius to Strasbourg. It was great pleasure for me to participate in the first event that Ludmila has mentioned under the auspices of the European Council, where we discussed with our Belarusian colleagues the possibilities that international law provides that would allow us to lead in the fight with gross violations of human rights that are happening in Belarus today. And looking at today's event, it's of course a continuation of what has happened in September. And today we have a chance to speak in more detail about the principle of universal jurisdiction, its implementation in international law context. Speaking about the events that took place in Belarus. Of course, I wouldn't really dare to speak about the basics, but perhaps still I need to say a couple of words so that we share common grounds for our further discussions and look at the mechanisms of implementation of universal jurisdiction further. So the question of universal jurisdiction arises from the question of criminal jurisdiction of states according to international law. State has jurisdiction of territorial character, and of course, there are no doubts that states have jurisdiction to persecute for crimes that were committed on its territory. At the same time, international law provides for an opportunity of the state to carry out its jurisdiction extraterritorially, by which I mean not talking about the events that happen on its territory, but outside of its territory. And here are a few reasons that a state can use for establishing this jurisdiction. First of all, an opportunity in many cases to establish state jurisdiction towards the crimes committed by its citizens abroad. State also has an opportunity to establish jurisdiction towards crimes that were committed against its citizens. The so-called passive nationality principle, passive citizenship principle. The principle of active nationality, of course, is more established in the international law and is not questioned a lot. But even passive nationality principle is pretty well established and usable. Then states can use protective principle, which would be applied to crimes that the state believes is aimed against its main interests. This principle is less established in the international law than the passive nationality principle. So I'm going from the most important to the least important here. But what's worth saying is that international law doesn't really object to establishing extraterritorial jurisdictions of the state most of the time. So it means that this extraterritorial jurisdiction can be successfully used and should not lead to any conflicts. Talking about universal jurisdiction principle, it's extraterritorial jurisdiction, not related to the crimes committed on the territory of the state, but the state is not attached to those crimes in any other way. So there is no citizenship link. A person, for example, who committed the crime, no link towards the victim, or very narrow national interest of a particular state. It means that this jurisdiction is based on the nature of the crime itself. It's very important. As Professor Žalimas mentioned in his introductory word, we're talking about the fact that the values are being attacked, the values which are fundamental for all states in order to secure the rule of law. So we're talking about the attack on jus codens, the universal laws of the international law. So states have obligations towards the whole international community. We're talking about erga omnes, not just to avoid committing certain crimes, but also to react in certain ways should they be committed. So basis for establishing international jurisdiction can arise from universal international law, contractual international law, the well-defined and easily implementable in cases where we have specific contractual obligations. But also using general international law is also a possibility that cannot be excluded, and speaking formally isn't in any way worse than the contractual basis. So we have to understand when we have an international contract, the application of certain paragraphs and the reliability of it is much higher. I also want to say, before we move on to the Belarusian events, so basically, there are two types of universal jurisdiction. First of all, is limited universal jurisdiction, which is very practical and can be implemented. And in some cases, talking about torture crimes specifically, it should be implemented by the state. So it's universal jurisdiction tied to physical presence. The human or suspect of the crime on the territory of the state that performs universal jurisdiction. So when this person is physically present on the territory of a state, the state may consciously and hope that it will lead to a positive outcome. It will lead to a successful legal process, and it can apply universal jurisdiction towards a specific person. So here we have non-limited possibilities for universal jurisdictions when a state in its criminal legislation provides persecution for on international basis for any individuals, regardless of their nationality and regardless of a place of the committance of a crime, and also regardless of the possibilities of its own legal system to reach that person. So talk about criminal procedure being performed with this specific person being present on the territory of the state. So this absolute criminal jurisdiction is of course problematic due to a number of issues in international law. Of course, it's understandable. It's not a secret to anyone who studied international law. There were instances when this jurisdiction would be imposed by the state, and of course, classical example is Belgium legislation until 1923, and it's also well known that international UN court in the case of Congo against Belgium in 2002, regardless of the presence of certain opinions within the court, critique this concept and talked about the violations on the side of the Belgium. So we're talking about anyhow, this decision was a step forward for Belgium to change its legislation and finally say goodbye to this unlimited concept of international jurisdiction. Again, realistically, I believe that the problematics of the Republic of Belarus, in this context, we should think of universal jurisdiction in the case when a person suspected of committing a crime against international justice is physically present on the territory of the state that implies international jurisdiction. Talking about the situation in the Republic of Belarus, what crimes are we talking about? First of all, mainly about torture. When we talk about torture, we have Universal Convention, and Belarus is a party to that convention, and the majority of states of the world are party to it as well. Of course, all European states. So it's a UN Convention Against Torture from 1984, which contains a number of very important articles which comprise the basis for persecution of persons guilty of serious violations of human rights, mass violations of human rights, including what's happening in Belarus, and also torture. So Article number 4 of the convention, the criminalization of torture, which is responsibility of a state, and also Articles 5, 6, and 7. Article 5 is especially important because it first of all obliges the state to implement criminal persecution for torture. Torture performed on the territory of a state towards citizens, and principle of nationality, and also in cases when a victim of torture is the national of that state, and of course with an exception for the state to deem this appropriate. But what is also very interesting here is point 2 of Article 5, in accordance to which each state party to the Convention Against Torture also has to take measures necessary to establish its jurisdiction towards committance of a torture crime in cases when the suspect is present on the territory of its state under its jurisdiction, and if the state is not extraditing this person in accordance with the convention regulations to one of the states that have established its jurisdiction towards this crime based on active or passive nationality principle or territorial principle. So Articles 2 and 5 of the UN Convention against torture should be interpreted in a way that it establishes the responsibility of the state to perform this limited universal jurisdiction towards persons who committed torture when those persons are physically present on the territory of such state. And I think it's very important, and it's also important to draw the attention to the fact that Article number 5 also has a provision number 3 that the convention does not eliminate a criminal jurisdiction that would be performed in accordance with the internal legislation of a state, which means situations when the state actually wants to establish jurisdiction, universal jurisdiction, even without limitations, without the obligation for a person to be physically present on its territory. But I believe it's important in the context of Belarus to implement point 2 of the Article 5 of UN Convention Against Torture. There is a pretty wide practice of Committee of Against Torture of the United Nations, which often critiques states for not fulfilling their obligations under point 2 of Article 5 of this convention. And talking about his son Hambre from Chad and his case, when his question was reviewed by the Committee Against Torture, I'm not going to go into too many details of that particular case, but I would like to mention that International Court of the UN, although it did not say so directly, that Senegal, in this particular case where Mr. Ambre was present, violated its obligation under point 2 of Article 5 of the Convention, the International Court still, the way it formulated its decision, agreed with the findings of the UN Committee Against Torture that such obligation exists. So what does it mean in practice? As I said in our first event, the states have direct opportunity to apply principle of passive nationality where the victim of violation of human rights is present on the territory of a state, but also talking about other crimes committed on the territory of Belarus by citizens of Belarus against citizens of Belarus. States also have an obligation to impose its jurisdiction and realize this criminal persecution. So that all arises from the UN Convention Against Torture. But of course, it also depends on the political will of a particular state. So those are very important moments. And I want to finish by saying that international law, of course, is very developed, but there are a lot of nuances still. The practical realization of criminal persecution for mass violations of human rights in the Republic of Belarus through the use of general jurisdiction depends on the political will of a state. And in this particular area, I believe it would be important to pose this question on the level of the European Union and European Parliament in particular. It could so thank you very much for your attention.